Ever shared your product idea with someone and then saw it show up online a few months later? You need to hear what today's guest has to say. What does it actually look like to get a patent or copyright? And what's the difference? Joining us today is Camille Wilson, a passionate attorney through Wilson and Dutra, who works with dreamers, creatives, and inventors to protect their ideas through patents and trademarks. If you've ever wondered when to patent your idea, how trademarks work, or how to avoid getting ripped off, this podcast is for you. I'm really, really excited to be joined with Camille. Welcome to the podcast.
Thank you. I'm super excited to be here.
So I just want to start off with just something a little bit about background. Can you tell us how did you get into this?
Yeah, so when I started law school, longer than I'd like to admit ago, but I guess almost 20 years now, um, I didn't know about, I had some familiarity with branding and things like that. I knew you could protect it, but I didn't really think about it. Then I went to law school and I absolutely fell in love with it. I took a class in passing. I took a class in real property. And there was like a one-liner about intellectual property. So I took intellectual property, and I fell in love with patent law immediately. And my background is biomedical engineering. So I found out that I could marry my biomedical engineering side with my law side, and I was like, this is perfect. And then I've been very lucky because I've been able to do patent law and trademark law since the start. Some people, they have this dream in law school and they don't get to do it yet, and it takes them a while to get there. I was lucky. Right out the gate, I worked for a Fortune 50 company, and I got to work in R&D, and I just turned out patent applications, and it was so much fun. And I've been doing it ever since.
Yeah. So what is it? What is the draw for you then? To draw with working with entrepreneurs and inventors, like what is it that you love about it?
So when I worked at that Fortune 50 company, I I just kind of sat in rooms where people just thought up stuff, and I just basically took notes and then went off and patented them. And then I went and worked with other attorneys, and it just didn't have that collaborative kind of, just productive nature and of thinking big and thinking practical. And that's where I ended up with my partner starting our own business. And we were like, entrepreneurs don't get that experience of being like having in-house counsel just sit there and think with them. And we were like, you know what? Why not? Why isn't that the model? So we kind of came together and said, let's focus on entrepreneurs and let's give them that environment so that they can build cool portfolios, they can build a business around their patents and not just create patents in a vacuum. So that's why I love working with entrepreneurs. And I also love working with entrepreneurs because once they get the bug, they can't help it. So we work with some clients on their first business, second, third, fourth, fifth, and it's so much fun.
Yeah. I know I was going to ask this question later, but which products or which clients do you tend to see do the best? Like, are there certain industries or certain types of products that you go, wow, that's going to be a good one?
So there's probably two industries that we've worked with that have been the most successful. Um, One is cybersecurity. We have some really sophisticated, cool cybersecurity technologies that we've worked with, and I mean they're super successful. They get funding pretty quickly because they are passionate about what they do and they can convey the value of what they're doing.
Nice.
On the other side, pet products. I mean, pet parents spend a lot of money on their pets, and
Mm-hmm.
I'm not even talking about just dogs. I mean, we have cats, chickens, everything, and it's also just fun for me because then our patent drawings have chickens and cats in them. I think we had a bat once, which was really fun. But pet products do really, really well. I think in part because they can get a prototype fairly quickly. I'm sure you've worked with pet products before, and they can get a prototype, especially if it's not really, really complex. They can get a prototype done, and they can prove their market quickly, or they fail very quickly, and then they can move on to the next product. So I think that's part of the benefit of the pet products.
Yeah, I agree with that. And the other thing about pet products is that there's such an emotional bond with people and their pets and their children. I think I've seen a similar relationship with children as well, but you know, people will spend so much on themselves, but when it's their pet, and especially now, pet moms and pet dads are like really trendy. I just saw this service that's sending uh flowers to pet parents, and they have little pet cards and stuff that are like from their dog, but you can send it to like the owner. I mean, it's just there's such a market there trending that it's just yeah, I think you definitely have a little bit better odds there.
Yes, yeah. And it usually comes with a little bit of passion about animals. So pairing that passion with the product is always beneficial, at least when it comes to marketing it.
Yeah. I love when just kind of jumping back to what you were saying about what you love about working with inventors and entrepreneurs. And it's actually really identical to what we do and why we love, because we do prototyping all the time, right? And
Right.
it's that passion that people bring in and obviously everyone thinks their project is the best and it's going to change the world. Um,
It might.
and it might. I mean, not every one of them do, but it's that passion that people bring in with their projects it's absolutely phenomenal. And that's why we do business. Even the way we do business, we do it because of the same reasons that you do, where that collaborative environment is so important. And so, like, where I never would have expected that out of patent law, I'm gonna be honest, because most of the lawyers I've worked for in the past were very much like, I want to do stuff in my office, and I'm gonna let my clients, like, basically I handled the clients and they handled the lawyer work. But so what does it look like when people are working with you to have that collaborative environment? What does that environment look like when you work with them?
Yeah, so one of the first things we start with is a brainstorming session. And that basically simulates a meeting that we would have in-house where time doesn't matter. Um, and we sit there, we think up, okay, what does my technology look like right now? Which is what most people protect, right? They'll protect my idea right now is A, so I'm going to protect A. And then you get A, and then you're like, oh, but I'm going to pivot because inevitably people pivot, for sometimes intentionally, sometimes because they have to. Sometimes strategy, but sometimes they have to. And then if you've only protected A, you've missed out on the rest, right? You missed out on B through Z. So what we like to do is in that meeting, we think of, okay, what does it look like right now? Patent lasts 20 years, right? So what will it look like in the next 3, 4, 5 years? And sometimes that's a wild exploration because it's especially with software, right? It's hard to imagine what happens in the future. But like, for example, we had a client this was, I don't know, 5, 6 years ago, and we anticipated generative AI, like at least enough to anchor it when it came to when it was actually feasible, which is really fun, like magical process. But we can do that with anything, right? We do that with physical products as well. You think, oh, maybe this gets smart in the near future, or maybe there's like an elevated version, and then there's like like a less complex version. What would competitors do? All those things get baked into this brainstorming session, and it's a really fun process because we want to find things that are, that someone could monetize. We don't want to give them a patent just because they want a patent. They need a patent to do something with it, whether that's licensing or selling the product themselves. So yes, yeah.
Yeah, we definitely see the same things. Like, that's one of the great things about prototyping is you don't really have it all figured out. And it's a process. I always tell people, it's a process. As you produce stuff, you're going to get feedback. You're going to get feedback from the product, but also from consumers. You're going to get, new ideas. You're going to see what's working, what's drawing people, what's not. And you got to have that space to move around. How does that affect the IP, though, as far as transitioning from one idea to another idea?
Yeah, so the way I like this analogy. So for every idea, it's like a meadow, right? And in the meadow, there's flowers that have already been planted. And those are, other competitors, maybe those are just other patents, there's just a whole bunch of things that populate that meadow. we try to fill in all that green with your own flowers. That way, when it comes to pivoting, it's okay. You pivot into areas that you've already covered. So when it comes to the patent world and you pivot, as long as it's baked in that base application, you have room to move. Now, if you only write about one thing, you pivot outside that patent application and then you have to start over again. But if you can navigate within that patent application, it doesn't affect your patentability. So let's say you do write about A through Z, for instance, in a patent application, or you populate an entire meadow with your application, right? With your beautiful flowers, whatever they may look like. You focus on one at a time. So you still get really specific, monetizable, if that's a word, patent applications and patents. But you get room to build an entire portfolio off of one patent application, which is really cool.
I mean, you're talking about the provisional application, right? Am I correct? Or are you talking about the non-provisional?
So wherever you start, I say build it in there. So if you start with the provisional, which for everyone's knowledge, provisional is basically a placeholder that buys you a year. It doesn't get reviewed. It kind of lives and dies in that 1 year time frame. And in that time frame, you can do that non-provisional that you mentioned, and that non-provisional is what goes through the process of getting examined and gets to be a patent. Either way, whichever you start with, you need to have a foundation. You want a solid foundation that allows you to pivot, that allows you to build a portfolio, if you so choose. You don't have to, right? You're not obligated to build a portfolio. Worst case scenario, which is what I like to say to everyone. So let's say you do file on A through Z is in your application, and you only ever focus on A. Nobody else can get a patent on B through Z because you put it out there and it becomes prior art to everybody else's patent or patent application.
Can you kind of give a little more example on that? What do you mean by like A through Z? Like, you said if you.
Yeah, so I'm trying to give a good example. So, okay, so this is my law school example that I give when I teach courses. So it's a little odd, but like if you had some hiking poles and you wanted to make them smart hiking poles,
Okay.
right? As an example, you could focus in on the specific sensors that might be durable enough to withstand, being struck over and over and over again if it was at the base of the pole.
Mm-hmm.
You could focus on the processing of the data to correlate the data captured with, let's say surface pressure or something like that, and GPS data. That could be a potential option. You could do the software side of it that interfaces on the app. So all of those things can be protected separately, but you can put them all in one application.
Okay.
And that way you can protect all those things at once. And even if you don't, it'd be really hard for someone else to get a patent that's close to it.
Yeah, that makes sense.
When you put a whole bunch of those applications into the one application, does it reduce the chance of the patent being approved?
No, so there might be a step where you have to pick which one they're going to look at, but truly what happens, if you've ever read a patent application, which I highly recommend for a fun Friday night, in the application there's a section called claims. Truly, that's what gets examined. It's just the section, and it's the weirdest section in the application, and it's usually like a page, maybe 2 or 3 long. That's what gets examined. So if you, let's say you do the whole gamut of things, you do A through Z, but your claims will only focus on A. So they'll only review that, and that's what that gets the ball rolling. The rest of it won't be held against you. So it doesn't make it muddier. If it's confusing as to which one you're picking, then they might come back and say, pick one. And then you just pick one. But that's not a substantive response or anything like that.
How does that work if you go to B then? Are you having to add more claims? Are you filing an amendment? Or like, how does that all work out?
Yeah, that's a great question. So that's kind of where I'm going with the portfolio building. So as soon as you start building up, let's say you do A, you do B. B would be a totally separate application with that same invention date. So that's the benefit you get. You get that date so that you only compare to things that predate that, right? So if it takes you a year to file on the second portion, you still get the benefit of that date because you had enough disclosure in there to put it out there.
Gotcha. But it's a separate application, or it's like a okay.
It's called a continuation in part,
I
the
gotcha.
technical term. So if anybody's listening and they want to ask their attorney about it, continuation in part is what they're called. But it's the same base foundational application with all the content. You're just picking a separate portion of it.
Okay, that's good to know. And what would you say are the differences that make up a good patent versus maybe like a legal Zoom or is that yeah, the patent? Because I get a lot of clients that say I did a patent myself. Like what's the difference there?
So there's two potential pitfalls from, and this is not necessarily just working with a kind of a patent mill type group, or doing it yourself, or sometimes patent attorneys just have the strategy. But the two main things that we see that cause a big problem are, one, going too narrow. If you don't give enough disclosure, and it's just like you say your whole thing is like A plus B, and you get C, and that's it. That's your whole thing. There's not very much room to, because you have to pivot with the examiner too. The examiner's going to come back, and if they don't ask you to pivot, you might have gone too narrow to start with. So if you're like, it has to be 1 inch wide and it has to be pink, that might be too narrow. And a lot of times, if someone's protecting A, when instead of A through Z, right, protecting A, they'll go that narrow, and then you can get a patent, but then it's not valuable in the marketplace, because if anybody makes a change and makes it green, they don't get the benefit of that patent. On the flip side, a lot of times people go too broad, which sounds like, oh, that's what you want to do. You have to be broad yet specific. If you go so broad, I saw this happen this was a while ago, probably 14 years ago. I saw one written by a person, and on its face, it seemed like a good patent application because it was nice and broad, but it didn't give enough specificity for us to cling to anything when the examiner came back and was like, oh, it's just like this. We're like, but it's not just like this because it does this, but it wasn't in the application. Those distinct differences that made it unique weren't highlighted in such a way that we could point to it. And you really do have to be able to point to it. So that's what we noticed, going too broad and general or going too narrow. Those are two things that we try to merge the two and have like broad yet specific. And I recommend that to everybody. And even if someone's doing it themselves, if you want to have some broad strokes, but get specific. I don't recommend doing non-provisionals by yourself, by the way, as a note. Use an attorney because the claims, again, are just the weirdest thing. And I see some hand-done claims that are just, it makes it tough to get examined, and then you're just kind of wasting your time. The provisional, it's debatable whether you want to be able to do it yourself. And people use AI, I've noticed. You didn't ask me that, but people use AI a lot now for their, particularly for their provisionals.
That's a great idea.
Um, one thing I would caution, and this depends on the platform you're using. You're putting it out there. Like, I don't know what the confidentiality rules are and what their data sharing rules are, because sometimes it gets just taken as part of the training data from then on. And if someone else tries to create an idea, your idea will be integrated into that next idea. So that would be my biggest cautionary tale there. I haven't seen it in place or in action, but that's my biggest concern when it comes to that, is the sharing of data.
So I have seen it. Maybe not
Yeah.
with patent, but I have seen it. So there was a company that I was looking at starting, and I used an AI to create a logo. And something inside of me said I should probably do a Google search on that logo before I did it. And I found out that there was someone in my exact industry that was using that logo across the continent in California. And so because of that Google search, I was able to save myself a whole ton of legal issues. But it's like, because I was using AI, I don't know where it came from. I don't know where the
No, we
logo's
can't.
coming from or what it used to design it. And if it was someone in Zimbabwe, then I'd be like, okay, well, they're over in the other part of the world, another industry, but they were in my industry in the same country I lived in, and I had to pivot. And that's when I actually went to a graphic designer and got the logo created.
Yeah. And on the same note, so I don't know if anybody heard the horror story where someone got disbarred because they just they put like the details of the motion and asked, I don't know, I think it was ChatGPT, just to spit out the response, but they didn't verify any of the citations and they were all wrong. So we've done this just to kind of test out. We had a client just test out I think it might have been Gemini. I don't remember. It was one of the, not ChatGPT that I remember. And they're like, has anyone invented XYZ? And it came back and says yes, and all these patents came back, and I think it was for software. And we checked all the patents, and the patents had nothing to do with software. I mean, they were like the most random things, and it was so bizarre that they made these correlations. And we've done, like, sometimes we use it to help with blogs, right? I think that's people use it in marketing all the time because it's somewhat innocuous, right? To use AI for marketing. And they do the same thing. They just cite to patents that are just made up, or they coincidentally line up to a patent, but then the patent has nothing to do with anything. So I would just, that's another cautionary tale about using AI.
Yeah, one thing I've learned about AI is it's designed to be agreeable. So if it can find a way to agree with you, it will, even at the expense of making up information. So when you ask it questions, you want to ask stuff that it's not a yes, it's not like agreeable. It's like, is this or that, or like, I don't know. I'm not like exactly an expert at it, but things to kind of consider when you're asking ChatGPT. Don't give it a way to be agreeable, but just ask it how it would do something or what to look at or things like that. And then it will send you more to like that site or that area or but yeah, I wouldn't consider myself an AI expert, but I have used ChatGPT with attorneys to do a pre-draft and then send it to an attorney to have things verified, and that saved me a lot of cost in our own legal for the business and for personal as well. So and actually my it was actually outside of IP law, but my attorney at the time was like, "How did you draft this?" And he was very impressed with what it came up with. But again, not everything in there was legal, and he's like, "You can't use this clause. You can't use this clause." Yeah. But everything else looks really good, and I'm very impressed with it. Because like, so it's I think using things the right way. It's not it works or it doesn't. I think just understanding, like you're saying, that it can be a benefit, or I don't know if you really think it can be a benefit, but
It can be a tool. I think it's a good starting off point for things. It's like using Wikipedia as your base for, like, okay, this is what I'm looking at as, like, if I'm looking up semiconductors, it'll point me to a whole bunch of citations for me to go look into, and I can dive into it further there and get the real nuances of the technology. And Wikipedia is a great, like, resource for that. But I wouldn't write my thesis off of Wikipedia, right? So that's kind of where I would go.
yeah, I think exactly. I think it's a great way. One thing that I've seen a lot happen is our clients will come to us with an idea that they've already gotten patented, and then we'll come up with a new concept, like a pivot, like you're talking about, and they'll say, "Well, we can't go that direction because the patent doesn't cover it. I don't want to pay for another patent." How is that a pretty common thing, or is that based on their understanding of the patent, or is that more based on the patent not being written well? Like, what causes that, and how do we avoid those kind of scenarios?
That's a great question. So the way to avoid that scenario is to leave it open. It's called leaving it open, leaving the chain alive, basically. Um, because inevitably you have to pick something when you're filing the application. So you do your best as far as what you think is going to be especially especially if there's like a long runway for the development of it. You pick your best, but as long as you keep it open. And what I mean by that is it hasn't gone abandoned and it hasn't issued. So either of those two things close the loop. As long as it's still pending, you can file on a new application that builds on the pivot. So let's say, for instance, we have, what was it? We'll do the hiking poles. Let's say the hiking poles and the whole thing kind of says, there's no way we can put the sensor in the tip of it. We have to put it somewhere else. and that created a whole new system for it. Or even better, the original thought was to build poles from scratch, and then during prototyping, you're like, no, let's just do like post manufacture, like adaptive version. Right? Those are two very different solutions. Having it pre-manufacture, post manufacture. Like one that would be a totally different invention. As long as the other one hadn't issued yet, there's still room to innovate, and you can build on that. You wouldn't have to do a whole new application. You could just build on it with this kind of offshoot, the continuation part that I mentioned, offshoot invention. So, and that's where the building in the pivot room really comes in. So if you haven't contemplated it at all, it's really hard to anchor it. But
So I'm not clearly super familiar with the patent process because normally that's where we use people like yourself. But how
yeah,
does that process, like, how does the issuing, like, do I decide if it can be issued, or are
ah,
we waiting on the patent firm? I mean, the patent
PTO,
the
the Patent
patent.
Trademark Office.
Yeah, thank you. The patent
Yep, yep.
trademark office to issue it, and we just start trying to beat them, or how do we control or influence that?
You have some control. So once you get an allowance, you get this letter, and it's like you're allowed, and it's like woo. You have 3 months to get from allowance to issue. And during that time is when we recommend filing the next one. You can file it before then, of course, because you're still pending, but that's when you really need to move. Technically, it takes a while for it to go. Once you pay that issue fee, it takes a while for it to go from issue fee to actually issued, but that is in the patent trademark, the PTO's hands, and you don't want to be, you want to be able to control it, right? So you do it in that 3 months, and you're fine, and it's still pending.
So you have about a 3-month window to really have some fluctuation. Okay, gotcha. And then that's you starting the next part of the chain, which would be filing another patent that's tied together. Can you share a story that, like, one of your favorite stories in patent law, or with favorite products maybe that you've seen go?
So one of my favorite stories is, um, I mean, it's a cat door. It's this little door that goes into a big door, like an interior door. And I don't know if anybody has cats, but you open it when you want the cat to go through it, and you close it when the cat can't go through it. That's the long and short of it. It's very straightforward, but really cool. It looks awesome. Some of them look like little hobbit doors. Some of them are like French doors. I mean, it's just adorable. It's like if I had a cat, I would get one because it's just too cute. Um, but she has a ton of patents on that technology, and she is the only one on Amazon. Um, and that
Wow.
is a tough thing to do, to have not have real knockoffs. I mean, there's like the old school flapped doors, that like
Yeah,
that usually
yeah,
that
like a
like the
barn, not even a barn door, like a mud flap almost.
yeah, yeah, exactly. Those still exist, but that's not what her invention is, and nobody else is a knockoff on there. And she just takes them down with their patents, and it's amazing. And the product's really well made, and she can control that narrative.
Now, I know that patents can be difficult to defend, but how does it work on Amazon? I'm sure you're from.
Yeah, so Amazon, it isn't. You're right. It is hard to enforce patents in general, but on Amazon they have a program. I think it's called the Apex program, um, that allows you to enforce patents directly through them. Um, and you can. The first part is kind of one side. You say this is what it is, and someone kind of decides on it. And if it's controversial, you can. The seller can choose to challenge it. And if they challenge it, it goes to this like internal board at Amazon. And it's not like true litigation. It's like like a mini court decision. It's not binding on anything, right? But it allows there to be a mechanism. It's kind of like the trademark side is the same, or similar, I should say, on Amazon. There's a platform to enforce on trademarks, on Amazon, that makes it easier to do. Um, Amazon's not always the easiest to work with, but they do have some things in place that allow you to leverage IP. It's not a foolproof system, right? There's still gray areas. But it's kind of nice that there's a platform that does that.
Yeah, for sure. I think, from my understanding, they're the best at actually abiding by patents. Have you experienced the same?
Yeah, they truly. So again, it's a huge corporation. There's a bureaucracy. It's not a perfect system. There's a lot of red tape, but they do have these mechanisms in place that help you defend it. Whereas it doesn't exist on. I don't think it exists on Walmart or eBay. It certainly doesn't exist on like Alibaba or AliExpress, right? That's just not like that's a wild, wild west. So that's its own thing. But Amazon does have these mechanisms that make it easier, that allow you to leverage IP in a way that you can't outside of that world.
That's great. Yeah, have you what was I going to ask? So in that scenario, if you're going, do you typically participate as a legal professional or as a patent attorney with the Amazon's um,
We
mini
can,
series, or is that something that
yeah, we can. Sometimes the client will do it themselves. But it's that user friendly. Is that especially in the beginning phases, you can do it yourself. Sometimes we'll have someone give us a product and just ask for a blurb, and we'll give like a little sound bite on it and see where that takes them. And um, it's pretty helpful, if I'm honest.
and how does that compare to, say, the open market or the traditional patent defense?
Then it takes you to cease and desist letters typically. And cease and desist letters are a thing that can lead to litigation. And so full disclosure, we don't do litigation, right?
Okay.
It's not, um, but we worked on cease and desist letters, quite a few of them on both sides of it. And it often leads to litigation for no reason.
Hmm.
Like that's what always surprises me when it's like it goes to litigation despite people talking. Someone's like fed up and just goes to litigation. You're like, that that escalated quickly. It's like in Anchorman. I saw you had a Triton. Do you remember that part of it when they do the big fight and he's like, and they just like that escalated quickly. That's sometimes it just happens and it's like someone just had a bad day and like filing suit. You're just like, oh, that's where we are. Okay. Um, so it gets difficult and it gets emotional and expensive. Um, so it's a thing unto itself. It's its own animal.
Yeah. Yeah, I always tell people if it ends up in court, everybody loses. That's that's like my personal perspective on that, I guess. After I've been through it a few times, so
Yeah, I mean, patent litigation is like $1 million. Like if you truly go through the whole thing, I mean, most times things settle and you don't end up paying that whole thing. But if you go through the whole thing, it's like $1 million, which is million, million five. It's a big chunk of change. That's why you typically see titans fighting
yeah, exactly.
when billions of dollars on the line, right? Because then you're like $1 million, done. It is worth it.
Yeah, and I've not saying that I have a lot of experience here, but I have seen uh I have been exposed to those kinds of scenarios, and even the big titans, they don't want to go into it because it's time, it's money, it's frustration. And it's normally not just one. I've noticed when it gets to that level, it's just like chasing fire ants almost, where they just, knockoffs start popping up all over the place.
Oh yes. So we do have that happen. So we have a client that they unfortunately they have a ton of knockoffs, like hundreds of knockoffs. Um, and they had to bring suit against them in chunks. Um,
Interesting. How does that work? Like, what do you mean, like, in chunks? Like, go after multiple people at once?
yeah, I think they did like
How
100
much
chunks, something
insulin?
like that. It was very interesting. Again, we don't
Yeah.
do that, but most of them settled. Some of them disappeared. Some of them ghosted them, and just dropped off the face. They stopped selling the product, and they just kind of poof.
That's good. Well, at least you're getting some protect. You know what I mean? Like, it's definitely taking some of that burden off of the market. Or yeah.
Yeah.
So, do you have any cases, just kind of looking at your history, is there any cases where you're like, these people were absolutely saved by their IP protection?
It's one of my favorites. That cat door one. I mean, to be able to monetize a cat door the way she has without knockoffs, I think is incredible. She's one of my like. I love telling the story because it's testament to how you can patent even the simpler products out there and leverage it.
So can you talk more about that? What do you think made that work so well versus, like the situation we just talked about where you see all these pop-ups come in?
Well,
What's the
they didn't do a utility patent. They did a design patent.
okay?
So, and for everyone's reference out there, a utility patent is based on functionality, and a design patent is how something looks. So, to get around a design patent is fair. They're very useful if you have molds and things like that, because you don't want someone to steal your mold, and then that mold will look exactly the same. But if they change up the way it looks a little bit, then they typically can get around a design patent.
Hmm.
If they change the location of something, that often can get around a design patent. If they change the general shape from a circle to a square, that can generally get around a design patent.
Wow.
Whereas a utility patent is based on how it functions. So if that square functions the same way as that circle, you're still infringing.
Right. And you said they had which one?
So the one that has the knockoffs is a design patent.
Oh, I got you. But the cat door was a utility patent?
Utility, lots of them.
Right. Oh, okay. Oh, I got you. Okay.
Yep.
Yeah, that makes sense.
And I'm not saying there's not a time and place for design patent, because there are. And I'm going to throw this in there because it's one of my favorite things to talk about. So you didn't ask me about it, but I'm going to tell you about it anyhow.
Sure.
Design patents can morph into, or you can start with so let me take a step back. You have a year to decide if you're going to do a patent. Once that year goes by, you lose the right to do a patent. It's as if you're giving it to the world. The world's like, thank you. You no longer get exclusive rights for 20 years. So that's something to keep in mind. Now, if there's something really cool looking about it, after about 5 years, sometimes less, if you become known for that look, you can get something called trade dress. Very underutilized, but if it has, let's say you have a product and it has a certain color, like a two-tone color scheme, you can get trade dress on that because people see that color scheme with that product and they think of you every time. That becomes trade dress. And that lasts forever because it's a form of a trademark. So what a design patent lasts 15 years. So if you get in on that, you're exclusively on the market with that for 15 years. And in that time frame, you can file a trade dress for that same kind of general concept. And from there, it strengthens your position because it's harder to get around trade dress because it's based on consumer confusion, and they don't give consumers a lot of credit. So there's a chance that a square and a circle are close enough for a consumer to be like, yeah, this is the same thing. And you'd get more protection.
And is that more protection than a utility patent, or is that more protection than a design patent?
I would say it's a stronger position than a design patent. You also get other types of relief and damages that you can't get with design patents. And again, I don't do litigation, so I don't know the extent of it, but I do know they're very separate things. So like trademarks and trade dress get into the world of counterfeits, whereas design patents don't. That goes into infringement.
Oh, interesting.
So there's like these different remedies and different damage that you can get for either of them. And I actually, this is funny. I just spoke to someone that's in litigation, and he said the best way to get someone to come to the table with a settlement is to throw everything at them. So if you have a design patent, utility patent, and trade dress, they don't want to fight all those things because they have to fight every point on it, and they don't want to fight that. They're just be like, you know what, whatever. Here, take this, and I'm going to back out of this product because it's very hard to get around all three.
Yeah.
So the more you have, the better it is, the layered it is, and it can be very powerful.
That's a prosecutor's trick. When someone breaks the law, they will do like first degree murder, second degree murder, manslaughter, anything.
Yeah,
So
you have to have defense against everything.
they will do like 15 or 20 charges. They'll only really settle on one. But when they bring them in, they're bringing them in like 20 charges in hopes that they can overwhelm the defense.
That's the strategy.
Yeah.
So
So what's the difference between if you wanted to do a like a U.S. patent versus a global patent?
Hmm. Okay, so international, that is a hot topic, and because we're a global economy, right? Things travel between countries all the time. um, so patents and trademarks, both of them, go by country. Um, so they go by, if I file in the US, I get US protection, patents and trademarks. If I file in Canada, I get Canada protection. Europe, Europe, right? And it kind of goes from there. Every country's, like, you can kind of go from Europe into each country. For trademarks, I think you have to go through each country individually anyhow. Um, but you also have to have unique attorneys for each one. So you have to have an attorney for each country as well. So there is something called a PCT, Patent Cooperation Treaty, and it is a placeholder. It's essentially a provisional, an international provisional. That's not the official term. Don't quote me on that. But that's how we position it, because it buys you time. It buys you 30 months, which is quite a bit of time, right? That's 2.5 years. Buys you 2.5 years to decide what countries you're going to go into. So that's very helpful, because then you can pick countries that are going to be useful to you, whether it's a country that you're producing in. So a lot of people do China because that's where they're producing the products. Um, or they'll pick a country where that product is going to be particularly lucrative. We have some clients that pick like 10 countries or 15 countries. That adds up so fast. So in the US, you don't pay for maintenance fees until you get the patent. And then you pay it like 3.5, 7.5, and 11.5 years. Because the theory is each time it gets, more and more valuable as time goes by. So you pay then. In other countries, in most countries around the world, you pay something called annuities before you even get the patent. So you're paying a yearly fee just to keep it pending. And that adds up. And you have 10, and they're each, hundreds of dollars. That's thousands of dollars every year for it not moving. Like, you haven't done anything. And then you have to pay the attorney. So it adds up very quickly. So I always recommend being as strategic as possible. You can do the blanket way, but it's just adds. If you have unlimited funding, hey, go for it.
Right. Yeah,
But
that's
most
not
people
our
don't.
client. We've yet to work with anyone with unlimited funding.
Yeah,
Um,
me too.
but how much are those incremental fees normally? You said there's like a different intervals. What are those
For
fees
US.
for upkeep?
Oh gosh, put me on the spot with fees. I don't know off the top of my head, but it starts off with like a few hundred and ends up to like 1,000. So it's not like $1,000s per time. They try to keep it so that
Right.
you're basically proving that, hey, yeah, I'm still around. I still want this
I
patent.
got you. So you're not just taking up space in the place, but you're proving that
Yeah.
it's relevant. Yeah, but then if you have that times 15 or whatever, I could see that getting.
Oh, so with other countries are a wide range of fees,
Mm-hmm.
and they
Yeah.
are yearly. Ours are, like I said, 3.5, 7.5, 11.5 years after you get the patent. But other countries are all over the place with their fees.
Yeah, of course that makes sense. Yeah. And then you were saying originally that you have a year protection starting out. What starts that protection, and when does how does that start?
So you have a year to decide if you're going to get protection.
Okay.
Um, in that time frame, typically, so if it's beyond a year, you can only protect what you did in the last year.
So what starts is it just you can backdate a year of your intellectual property, or how's that year
No,
start?
it just monitored. So let's say you launch a product in 2023,
Mm-hmm.
and in 2025 is when you filed, your own product will be held against you,
Gotcha.
which is unfortunate. We've gotten around people's own products by changing enough, but it's still a challenge that is kind of avoidable if you speak to someone soon enough.
Yeah, so if you can start selling the product and then patent it, but you only have a year, is that what I'm understanding?
Yep, year for it after it goes public. So if you have people under after it goes public, that's a good point. Yeah. So if you're like in talks with manufacturers and you're under like an NDA, a non-disclosure agreement, um, then you're protected still because they don't want to penalize someone for not having their own in-house development, right? Their own
Right.
in-house R&D. But once you start selling it, once you start pitching it, things like that, that's what starts that timeline.
Gotcha. And how is that different than having a provisional patent?
So you have that year to decide if you're going to do a provisional,
Okay.
and that provisional buys you a year of actual protection.
Oh, okay. So you could be developing the thing the whole time. You can start looking at manufacturers the whole time and that's not counting against you. And then you want to go to you're like, I started selling. You know what? Let me go ahead and do my provisional real fast. You get that on, and then you still continue for another year, and you're
Yeah.
good through that whole process.
Yep.
Okay. So that being said, when do you think is the most optimal time to decide to patent something or to start this? And how do you go about making those decisions?
So I like to say it's based on risk aversion. If you are super risk averse, the sooner the better.
Mm-hmm.
If you like, some people don't want to talk to even a manufacturer with an NDA until they have something filed.
Right.
I mean, some people are like, no, I want to feel really comfortable. And that's what we do. We will file something that's nice and broad and specific so that they can, no matter what they bring like if someone brought something to you, we try to make it so that no matter what they bring, what you bring back to them is still within the realm of their original provisional.
Mm-hmm.
Um, if they haven't fully developed the product, we don't tend to do the non-provisional because it doesn't make sense because then you're locking down what you want to protect. But if they're
Right.
really early on, provisionals make sense. Provisional patent applications. Um, they typically make sense. There's never, and you're gonna laugh because of course I'm gonna say it this way. But there's never too early to speak to somebody.
Mm-hmm.
Now, whether you file really early on or not, I like to say there are no bad decisions. There are only decisions that aren't made. So if you decide not to file a patent application, but you made that decision, just operate under that decision. If you decide to get a patent application filed or to get a patent as fast as possible, then operate that way. It's when you don't make decisions and you're kind of flying blind that bad things happen.
I agree completely. Yeah. I live in the same ideology just in life. It's like it's not it's not whether you do it or not that's the right decision. It's just having the intent to do what you want instead of just letting life control your narrative. Are you reactive or proactive? I think that's an
Exactly.
important separation just to live by in life. So yeah, I definitely completely agree with that.
Oh, and I want to throw this out there because not everybody knows about this. If this is helpful tidbit for everyone to know, just like a fun fact, there are two timelines when it comes to a non-provisional to go through the patent process. One is it typically will take 2 to 4 years. We just got back a design patent application that took 4 years to get back from the Patent Trademark Office, even a response. Or not for design patents, but for utility patents, there's something called Track 1. You pay some extra fees, and they're not egregious fees in the scheme of things, and you get seen within 2 to 3 months.
And what would be the benefit of that?
So if you want a patent fast, that is the way to go.
But if I guess what I'm getting at is if the patent backtracks to the filing date, then what benefit do you get? And I really don't know the answer to this. What benefits are you getting by having it sooner?
Yeah, so you can enforce sooner.
Okay, so someone's already infringing or someone's already competing. That makes total sense. Yeah.
Yep. And it's really people that are doing really straightforward products tend to want it more often. Well, I'm gonna say we work with entrepreneurs, and entrepreneurs are so excited that a lot of them go for the fast track just because that's track one, just because I mean nobody wants to wait 4 years to hear back from somebody. Like that's a long time. Um, but people with simple products, Invention with simple products, it's very helpful to get it sooner rather than later. And really, really complex products like software, where No, let me take that back. Software tends to be beneficial to get it faster also because it becomes obsolete so quickly.
Oh, wow. Yeah, that makes sense.
So if it's a really fast moving industry, whatever that industry is, and it goes obsolete within 3 or 4 years and you want to enforce on it at all, you don't want to wait 4 years for it to become patented. Because by that time you're like, I don't care about this anymore. So if you want to start enforcing right away because you want to stay really relevant, then that's what we recommend. And most
Yeah.
people do it, quite frankly, because yeah, nobody wants to wait that long.
Yeah, I only have one patent, and I did through a university and their attorneys, and that was a multi-year process. I think it took us 2 years, and so that's really where the majority of my experience comes from, and then just talking to different people for different reasons about different things that they've experienced. I had a question. I
We're nearing the end of our time at the moment.